You're listening to the Valley Current.
So welcome into the Valley Current, part 2 of U.S. versus John Bolton. I have to say, I saw him on TV last night, and he's got kind of the wrong voice for the kind of gravitas that this case is about. I don't know if you watched that interview that he did. I was like, man, this guy doesn't really have the voice for the weight of authority that he wants to bring to the table. But hey, John, you've got a decent voice. I'm just saying, I wish you had that deeper sort of resonating sound voice that jurors love in the way I present cases. And of course, I'm not being very humble here, but you appreciate what I'm saying.
I never think of him as an authority. Frankly, I've always thought of his book as sort of gossip. I don't think of it as heroic or thoughtful, but I certainly think he has the right to publish it.
Well, the interesting thing this morning is that I've been following the tweets that are fired because people are in the courtroom and they're live tweeting. And the live tweets are so instructive because essentially this judge is right in the middle. I mean, he is being like an umpire. He's calling a strike, and a ball. And he castigated the lawyers for Bolton, saying you should have filed a DJ action. You should not have stepped forward. What you do is you come to me. I'm the friggin' parent here, and you're the kids. And if you want some direction when there's a street fight or a food fight, don't start throwing the food around. Come here and I'll give you some attention quickly and we'll work this out. So, as much as the government can be chastised for firing this ginormous nuclear war against Bolton, it's not like they really did totally the right thing on the Bolton side. So I'm trying to be as fair as I can to both sides here. I know you are too, right?
I thought the judge began the hearing by asking them, hasn't the horse already left the barn?
Yeah, that's what we all think because we come from that era. We come from the era of that's the way people thought about TROs. If the status quo has already changed, forget it. You don't get a chance to kind of, unring the bell. These are all the famous things, cat out of the bag.
Right. And isn't that still the law? And doesn't he seem to still respect it?
Yes, Rule 65 is still the traditional role of equity. Equitable courts in equity look at the equities, and it's driven by lots of things that people say, well, what does that have to do with anything? And say, well, the law of equity is different than the law of legal matters or damages matters. You're now petitioning to the chancellor, and the chancellor gets to decide what's fair. Well, what the hell does that mean, fair? Well, that's what fiduciary duty is all about as well. It's an ethically bound, almost biblical, if you read your book, and make sure that the video has the full, Monty, because this is the treatise. This is, I said, over 800 pages. It's actually over 1,500. It's almost twice as long. It's almost 1,600. Maybe you'll tell me the next version, because I thought this was the second version.
This is the first hardcover version.
This is the first, right?
And the second one, I'm deciding whether to print a second one, which will be closer to 2,000.
Yeah, I mean, the law just keeps growing. And the other thing I should say, because you kindly gave me a copy, and this is good for all the law professors, because I teach sometimes various business school and law school classes. You also did kind of a teacher's manual, which is much smaller. Literally, I think is less than a couple hundred pages. Maybe,
right.
I don't know what the total is, 217. It's called, kind of the fiduciary law and practice mini version. And then, just to give you a little PR before we get into the substance, you got the teacher's manual, which is like 50 pages. So it's like, do you want the ginormous, complete, ginormous book? Okay, 2,000 pages. Would you like the 200-page version, or would you like something you can actually read in bed because it actually opens up and it's a really good treatment? I mean, beautiful books, Rafael. I have to say, your brother, bless his soul, is probably looking down saying, man, I could never do all the work that Rafael did in putting together those books. No way, no how, right?
The last two are a textbook for law students and business school students.
Right.
And they include a lot of links to the ebook version of the big thick one.
Right. And I think they're both very well done. And I have to say, I do think you have done the most work that I'm aware of in the area of fiduciary duty law. And I gave you credit today on a tweet with all these guys in DC, because I'm a member of the bar in DC, and I occasionally am there to argue an appeal or something. And I said, Bolton, the government, Bolton's lawyers, you guys on all your commentary, your constitutional lens is clouding the fiduciary duty issues that we have identified on our first podcast. This is part 2. Part 1 was before the TRO was filed. We just looked at the complaint. Part 2 now is we've looked at the filings. The government did file a memorandum, did file an interesting declaration saying, hey, this is all secret stuff. And by the way, I can't tell you how I evaluated that it's secret, because even the process is secret. There's like an expert, this guy Nagasone. It's an interesting question of how the government is skirting kind of the law of secrecy with the law to understand whether or not it's true or bullshit, sometimes called the Bear test on experts, right?
It's very hard for me to grasp and sympathize with the law of secrecy. I think it should be much more limited. I don't think classification of documents is a complete bureaucratic nightmare in a toilet. I think it should be much more limited.
Well,
and
when you make a choice to do something that's not commercial private arbitration, because you do have a choice. If you want to negotiate an arbitration agreement with whoever is the counterparty, or a mediation agreement, those are absolutely secret processes. They are bound to remain secret unless people get a waiver. But
right.
When you take a choice of the courts, you're essentially in a publicly financed system where the public gets a value from the outcome and from the process, both ways, because you want to understand that the process is legitimate. So you need transparency. You need all the fiduciary principles applied to judges and to the court bailiffs and all the rest, right?
Most of them. The private setting which you describe doesn't have a problem, because what we're agreeing is everything that's said and everything that's filed in this proceeding is confidential. So there's no question in either party's mind about what the agreement covers.
Right.
But in Bolton's case, he's signing 7 or 8 pages of agreements with fine print.
Yes.
And nobody knows what the hell they cover. And we still don't know today. And the government didn't know.
And the government is a little bit flummoxed by probably the fact that Bolton even set out to do a book while he was still serving, because the writing of it pretty clearly.
Well, wait. He left, the book manuscript came out 2 months after he left, right?
Right, but the process of writing it began for sure. Like if you wanted to do work for hire doctrine and try to look at how much of that was done on firm time or done on government time, there's no question in my mind that he was observing in real time in ways that even today you might say, God, I wish I knew that he was actually taking notes.
Well, he was a compulsive note taker. I read in these documents, he took pages of notes for every meeting.
Right. So you could argue this is called a supplemental pension account, or supplemental IP pension planning, which anyone would say to him, normally you have a right to express your thoughts. You have to abide by agreements you sign. Those agreements should not be read strictly against you, but don't assume that they're going to be read totally in your favor. Take the neutral view, as I think this judge is doing, and say, okay, what's fair under the agreement I signed? And it looks like he started a process. So this Cooper firm, the guy who's arguing the case, it's not a big firm, but reasonably well-respected firm. Yeah. They've been around the block. They've done this stuff before. And, they look like they played the process out. They obviously decided, they must have consciously decided, because they know how to file lawsuits and they know how to file DJ actions, declaratory judgment actions. They decided, we're not filing in this case. We're going to play this thing out to the 11th hour, and then we're going to press go, right?
I think the burden of proof lies with the government, and that was probably a big point in their thinking. we haven't heard the judge's ruling yet, right? He probably takes it under submission.
Yeah, I think what's going to happen here is the judge is going to likely issue what might be called a procedural order, even beyond the procedural order that's set, the 10 a.m. hearing, which has now been completed. So literally we're podcasting about an hour after that hearing started. Right. The hearing started 10 a.m.
Right.
California time, 1 p.m. I think it's over right now. As best I can tell, it's over. At some point, I'll put up what the sort of tweets are that are sort of running. They're still running. The tweets are still running because people are trying to figure out, which way is up and what's likely going to happen. And they're doing it in the Twitter sphere, as we like to say. We're doing it in a podcast with the view of what is it that came out of this hearing that adds some knowledge, some value to the knowledge base that we have from the pleadings we've read and the arguments that have been made. And the three takeaways I get, but you match them or disagree with them, are: one, this judge is being extremely neutral, right down the middle, optics matter, he's going to be an umpire. Two is the government got slapped, but also to some degree Bolton's and his lawyers got slapped. More Bolton's lawyers than I think Bolton got slapped, on the view that, you come to me and you make sure that what you're doing is something that I can bless, because you did effectively allow, and this is the third point, the cat is out of the bag, the horse is out of the barn, the bell has been rung, you're getting whatever value in the sort of selling process of selling the book. That arguably was an advantage you took as a corporate opportunity that you shouldn't have took. It's an interesting fiduciary duty law question.
That's an interesting. Yeah.
You follow what I'm saying? It's really a nuanced question, which is, can you separately argue that publicity amplification was something that was expressly reserved to not occur under that contract, that there should have been some accommodation or some sort of mediation or something before it happened, that sort of thing?
Well, the whole intellectual property phase of this, the government says we own this information. That's very problematic for me.
Yes.
That the government, quote, owns the information.
Yes.
The second point is that the act of creativity required to write a book belongs to the creative person, which is Bolton in this case.
Yes.
Whatever that is.
Yes.
So the whole concept that they get whatever royalties he gets doesn't really convince me as being fair. Now, I understand it's a disincentive to employees to breach their confidentiality obligations, but I'm not sure I don't know if it's ever been applied. Was the SNEP case, I have to read some of the cases referred to in these briefs.
Right.
I haven't had time to do that. Did they allow the government to have the royalties?
Well, my recollection of SNEP was that he had signed a very harsh agreement.
Yes.
And that the government's view was, look, you really have waived your rights. And the Supreme Court agreed that there was a waiver of rights, that essentially there was enough expression of the waiver in, understandable terms. Now, I forget, frankly, what the outcome was on the money. But generally speaking, I thought, gosh, this is really an interesting situation, that you can actually waive your rights to something that you clearly own without necessarily assigning those rights. Like, it's not that you assign the rights and they're going to pay you some consideration, so it's a commercial transaction and you're bound by your contract. It's you're waiving your rights of publication. You can write whatever you want, just keep the manuscript in the safe and make sure only you see it. Don't even let your wife see it. Don't even let your spouse or your partner see it, period.
Uh-huh. And this was from the 1980s, wasn't it? SNEP was in the 1980s.
Yes.
Yeah.
Yes.
I haven't read all the opinions that they cite. There are several interesting ones here.
Yes.
The government has a legitimate right to classify information and to suppress classified information. All right, I can that's anticipated as a result.
Right.
But what exactly does it mean? And in Bolton's case, wasn't there an exception for whistleblowing rights?
Yeah, and I've got to go back just like you, and I haven't done it. I haven't had the time to do it, but I agree with you that there are some issues of how far can SNEP either apply or not apply. what I want to do just for a minute, because I think it would be helpful just in setting some structure, is I want to put up sort of the current blogosphere. It's all happening under Bolton hearing.
Okay.
And unfortunately with Twitter, there's a lot of junk you have to go through. Sometimes there's advertising, sometimes there's a bunch of other stuff. But I just clicked the latest, and you'll see these various Twitter handles like Clearing Fog 7 minutes ago. Remember, the White House could have filed an injunction prior to this and actually stopped the entire book from ever seeing daylight. They chose not to. Now it's too late. They're putting up an ineffectual fight. Don't trust Bolton or the White House. That's a sentiment you might.
What do you think of while he was in conversations with that first woman? Why didn't they file an injunction or get a stipulation to postpone publication? Why didn't they do that?
Because that's sometimes called a standstill agreement, and it happens in lots of contexts, which is we're just going to stand still until we know, and then when we know we're not standing still, instead of somebody bolting.
Why didn't they do that?
Well, you could argue there's a form of malpractice there by the government, but not really malpractice for a government lawyer to screw up. Or you could say they got out-lawyered, that the Cooper people maybe like them, don't worry, we're working with you. It's sort of a little bit of a questionable of the attorney ethics aspect. What's the attorney ethics here?
Yeah, but right? I agree with the narrative in the defense brief that this new guy was brought in at the last minute and did another review and said, oh yeah, there's SCI stuff in there. Yeah. I mean, that looks to me like a real phony. Yeah, phony baloney, pretextual way at saying, get the embarrassing stuff out of this book. It really looks like that.
All right. And so here's some stuff that's interesting. I don't know what the DOJ lawyer thinks he is accomplishing here. He can smear Bolton all he wants and say he should have complied, but just seize the proceeds. You're not getting an injunction at this point. These are all opinions, and I'm only looking at the latest ones. And if you really want to filter, you look at only those that are either retweeted or commented, because there's a lot of junk. There's probably 5,000 remarks here, but you're trying to squeeze the real juice and get rid of all the chaff, because there's a lot of chaff. Some people are well known. Bottom line, an injunction on the book would be clearly unconstitutional. A constructive trust requiring Bolton to give the money from the book, he says, to the government, I would say to charity, but let's leave that aside. Maybe plausible under SNEP versus U.S. I think it was actually U.S. versus SNEP, but people don't get the citations right. Wouldn't be heartbreaking given Bolton's refusal to testify at the impeachment hearings. Now, why did Bolton not testify at the impeachment hearings?
Why not?
People had three views on that at the time.
One was to get publicity for the book.
Yeah, one was this view that he really wanted to protect himself from a subpoena that would have gotten drafts of the book and would have caused the government to do what that one author says, just go in and shut the damn thing down, wanted to keep that secret. Another view was he was being loyal to the president as much as he disagreed with him. And the third thing is he was just kind of like drumming up fomentation of what the heck is this guy going to say? And he didn't want to kind of release his right of first publication of what he really thinks.
I think that's what I thought was the reason.
Right. It's a little bit like, I'm not going to let you pull my opinion out of me until I'm ready to be paid for that opinion. He probably got a $10 million advance for this book. I mean, that hasn't been released yet. I haven't seen anyone say what the advance is, but I bet they're printing like 10 million of these books, and I bet they expect to pay him at least $1 a copy. I mean, maybe even more than that. They probably pre-sold at least 1 million of them. I know Amazon was pre-selling them like a month or two ago, maybe even more than that.
Right.
So here's one. What I've gotten from this Bolton hearing is the book is coming out, but Bolton gets no money. Maybe Bolton doesn't care about the money. I don't know. I would think Bolton probably would care somewhat about the money. But maybe, his lawyers are like, this is great pro bono. We're going to get a lot of publicity from it. You don't have to pay us. Maybe. So then there's someone that mentions Pentagon Papers. There's a bunch of stuff about constructive trust. Why don't you spend a minute telling folks generally what a constructive trust is? Because this really does get into law school and what it is that you learn in law school about what legal fictions are. Of course, there's all sorts of ads that we'll pass through, but I'm just kind of curious what.
Oh, well, the constructive trust idea is simply that if you come into possession of property, which was trust property, which you had no right to possess for yourself,
Right.
then you hold it in not an express trust, but a so-called constructive trust, which is a legal fiction, a legal construct. The law imposes a trust there, and you hold it as trustee, and the beneficiary gets it no matter what you do with it.
And let me tell you what the modernized definition that I've seen that actually people seem to get better than even what you said, which I think is very excellent. People have said a judge can create a fictional LLC, limited liability company, that bear hugs an asset or a set of assets. And the corporate opportunity doctrine that plays out for the reinvestment of those assets creates a tracing remedy into other assets that the LLC also owns. And I tell you, when that's presented to students, they get it. They're like, oh, so the judge can create this phony LLC that doesn't really exist, but the judge says it exists. And then everything operates under more or less LLC law to say, hey, that LLC was raped. So we're going to take everything back and everything's going to come back into it.
Well, that's sort of right. I call it a constructive trust with tracing.
Yes.
And, you can trace, I give a lot of hypothetical examples, but if I go into your house and I steal your silver candelabra.
Right.
And then I go, and it's worth $1,000. And then I go to a pawn shop, get $1,000 for it, and invest in diamonds, which turn out to be worth $10,000. How much do I owe you? $1,000 or $10,000?
Yeah, I think you get the higher number, right?
You do, because I act as a constructive trustee from day one.
Right.
But I'm a thief, so this isn't a really good example. But if I'm your partner, and I agree that we will keep the candelabra and share the benefits of it, and then I take it personally and get $10,000 for it, I owe you not just your half of the candelabra, but all the profit I got from it.
So what people should know in real life is if Bolton got $10 million as an advance and $1 million is sitting in the lawyer's account, let's make it interesting because the lawyers have to be paid, I think, for some of this work. Let's say he gave them $1 million. They did it as a project fee. We're going to take care of you, John. Not to worry about hourly bills. We like that. We don't have to keep time records. $9 million he puts into an investment in Amazon stock.
Correct.
And the Amazon stock doubles over the period that the government is litigating.
Correct.
Now there's 18 million. He doesn't get to say, well, I'll give you your 9 million back. I'm going to keep the 9 million that I made on Amazon. He's got to give the whole 18. And I think he's got to give the legal fee back too. The 1 million that went to the lawyers have to come back.
I think so.
And the lawyers are considered essentially aiding and abetting in some weirdo kind of way, even though they have a right, First Amendment or otherwise, a Sixth Amendment right, a First Amendment right, a 14th Amendment right, maybe a Fifth Amendment right to make arguments about, hey, I'm here representing them and I should be able to be paid for my services. The law comes in, I think, and says, you took a risk here, man. And you should have studied a little bit of fiduciary duty law before you did that and gotten some independent third party to pay you that $1 million. And then they could deal with John on whether he was going to reimburse and how he was going to reimburse and all that jazz. And maybe, your $1 million would have been rock solid, paid irrevocably. But you took that $1 million right out of that 10 million that was tainted.
That's right. So one of the things that maybe should have happened is Bolton and his lawyers should have gone to court early and said, here's the situation. Yes. Once they knew there was review going on.
Yes. And you could argue that if they were really super savvy, and we're being critical without really knowing what all the facts on the ground were, but to be critical and maybe constructively so, if any of those lawyers decide to listen to this, step one would have been get a standstill agreement. Step two would have been, when the standstill ended, go to court on the DJ action that the judge told you should do. And step three, negotiate both step one and step two with a view that government, if I agree to steps one and step two before we get to step three, $1 million of that money's got to be earned because I'm doing work here and playing by the rules.
Right.
And you can't take back. If you end up taking 9, if that's the way the judge rules, but you're not going to take bread off my table. I got to run a firm here, man. I got to keep the lights on. This is not a pro bono shop.
And I think the government would have agreed to that.
Absolutely. I mean, you could argue the fiduciary duty those partners had to their firm was ignored. If you say that a fiduciary duty, maybe they did, maybe they didn't, but let's assume they did. They were multiple fiduciaries. They're acting for the client, but they're also got to look at the firm. I mean, the firm may put in $1 million worth of time and end up getting zero, and not for a lack. I mean, if they made a call to you, you're not, super expensive, but even if they spent $2,000-3,000 with you for a few phone calls, you would have told them exactly what to do in accordance with fiduciary duty law. And they would have saved millions, like what could be millions here, because they may end up with zero. And they may even end up becoming defendants in an extended version of this lawsuit if they decide not to put the money into an escrow account, because that's coming next, right?
Maybe.
I mean, if I'm the government and I want a provisional remedy because I just got slapped down on my TRO, how about getting some sort of attachment on the view that, hey, I've got a contract. That contract gave rise to money. The money wasn't expected to be at the level that it was. And I think we need to make sure he doesn't send it off to some asset protection trust in Belize or something, right?
Right.
Some place where I can't reach it because crazy laws, international laws won't let me reach it.
That's right. It's interesting. It's a very interesting thing. Obviously, Trump is really obnoxious. He is obviously behind the efforts to suppress this. The things that the book contains are offensive to Trump, but I don't find the book particularly profound or thoughtful. It's, as I said, when I first heard about it early this year, I thought it was just gossip. Or late last year.
It's gossip from someone who can sponsor what looks like gossip that has substance. I mean, the problem is it's not gossip from, remember back years ago, Hedda Hopper, decades
No, it's
ago,
not.
The gossip of what's going on in, Hollywood was Hedda Hopper's bailiwick because she went to lunch and breakfast and dinner all over town. But it's gossip from a guy who was there in the room.
Right.
And you could see the pictures of him, and he's very stoic with his mustache. And there's jokes on here like who's representing the mustache, because the mustache itself has trademark value. I'll just note a couple of other things. There is a view, Bradley Moss is the particular lawyer. He's at Brad Moss. If you want to see the contrarian view, it's expressed in things like, and Brad, if you want to call in at some point, we'll have you on the show. Wrong. Cooper trying to argue. Cooper is Bolton's lawyer. He's the named partner. Cooper trying to argue that the NDA only applies for a period of time. Wrong. All capital letters. It is for life. Capital letters. LIFE. I mean, there's a guy that knows how to tweet. There's a guy that knows the power of the capital letters, the power of being punchy, the power of telling it like it is.
But the issue with the SCI is not the length of time that it applies, it's whether there is any. They didn't identify, Ellen Knight never identified any. And this second guy comes along and says, oh, it's full of SCI. I mean, it's inherently unbelievable, really.
Well, remember that SCI is in the eyes of the beholder. I mean, that's the problem here. State secrets, just like trade secrets, just like, any secret, is in the eye of the beholder. If someone says, hey, I'm thinking about getting a divorce, that's often very secret for a long time, even from the spouse.
Right.
But he's telling it to like 50 different people.
Right.
I mean, come on. People are talking about it in the coffee shop. It's not a secret anymore. But man, in that guy's head, I told you that in confidence. How dare you put it into a tweet?
Yes, but the basic law of confidences is once it becomes publicly known, the confidentiality evaporates.
Right, but people don't realize that corollary that you just gave. That's just sort of like people think if I trusted you with something that I thought you would never sponsor, the fact that you sponsored the statement has a negative value beyond even the gossip that's floating around because of people that take pictures and don't see me hugging my spouse anymore, as Obama got accused of. That was the person I was thinking of that might have told some of the secret that he was thinking about getting divorced. By the way, footnote, I'm not getting divorced. Rafael's not getting divorced. To the best of my knowledge, Barack Obama's not getting divorced. We're just using it for illustration purposes. And the illustration is the sponsorship often has a sort of punch to it that creates sort of a real sting.
I dig, but
upset about.
But the law of confidentiality is not an assignment of public relations value.
Yes.
It is confidentiality. And once the fact becomes known, the fact that I, quote, sponsor it may be a breach of some kind of loyalty, but not confidentiality.
Right. But people get confused about that.
Yes, it is confusing.
They get very confused, and it takes someone like you or me to disassemble it and to put it on a whiteboard and to say, you're thinking this way, but the Venn diagram goes in a different way.
Right.
So let me give another example of, sort of this view that goes back and forth, because you'll see at least 3 to maybe 5 different types of views. Brad Moss is obviously the view that, hey, a contract is a contract. If you misunderstand it, Mr. Bolton, or if your lawyers even misunderstand it, too bad. So here's Adam Steinbaugh saying, I think he's a news reporter, they're discussing whether Bolton met the requirements of the review process. I know little in this area of law. I don't have much to add here, but check out Brad Moss, check out Mark Zaid. So these are commentators on the commentators saying for the nuances of this. And if we go and you can click, and so we're giving a little tutorial, you can go to Mark Zaid's site, and Mark is an attorney, and he involves and does do cases involving national security.
All right.
This SCI is a form of what people claim is national security information. And he's commenting like, I am told that Knight, meaning the person you said, did have final authority to approve Bolton's manuscript, but tentative verbal approval is likely insufficient, meaning Knight giving a verbal is not the same as an email, which is not the same as an ink-signed document. Right?
Cooper argued that oral approval was adequate under the documents.
Yes. Yes.
I didn't review them to see if he's right, but it could be.
Yes. And so people do a little marketing in these tweets. I always crack up. Bolton TRO, here's Zaid. Having handled pre-pub cases, meaning cases like this, for 25 years, I've often seen the government initially say info wasn't classified, but then the decision is overturned by others.
Okay.
Until the client receives formal authorization and determination, no publication can happen. Bolton needed to wait, and he should have added and or file a DJ action. Wait and file a DJ action, right?
Right.
And here's a quote of the judge. I love when people like Steve Nelson quote the judge. Bolton had this is apparently a quote. Bolton had an obligation once he invoked the process. He can't walk away. He didn't tell the government he was just walking away. He just walked away and told the publisher, go publish. That's like the judge says, that really is wrong. That's unethical. That's deceptive. That's misleading. So this is my point that I started with. I think there's a certain spanking going on both ways.
By the way, the consequence of this is that he may lose the lawsuit, but not a TRO.
Right. The TRO is an extraordinary remedy. Think of it as if the Golden Gate Bridge is going to fall if a judge doesn't do something.
Right.
There's a lot of irreparable harm that just can't be compensated in money.
Right.
Cars are going to fall off the bridge. People are going to die. The judge is going to enter a TRO. Someone's going to go enforce it. This whole situation involving a gossip book, as you put it, where a lot of the information is already out in various tweets with the President of the United States. The President of the United States is taking Bolton on in Twitter and opening the door to what is left to talk about. I mean, it's all out there that he talked to the Chinese president about, hey, buy some farm equipment or buy some
By the way,
something.
On that particular point, having the Chinese buy farm products from American states is good for our country.
Right. I mean,
so I don't understand why that fits into the Ukraine model.
Because they're sort of turning everything into self-interest.
Yes, I understand that.
Another interest. You're rightly seeing another interest and saying there's other interests, right?
Right.
So this is sort of like, the people put in photos. So I'm putting this stuff up just to get some
Okay.
hilarious value. They put photos up. You got to be kidding me that you're doing this. This is me listening to Bolton's legal argument. So there's a video here apparently of, this movie that's playing. What's our summary? How will we summarize this part two? Because maybe you would say this is a lot about nothing, and it's more maybe for law professors or students. It's sort of like a tempest in a teapot between litigants and the government. We could argue the lawyers made some mistakes. We could argue the government made mistakes. We could argue, but it doesn't look like the judge is making any mistakes. So our prediction would be, I'll give you mine, you give me yours. No TRO. I'm not even sure preliminary injunction hearing. I think he's going to say, stop wasting my time. Right. No equitable relief, except if you want to bring a new motion as part of your trial for what we do with the proceeds. I want those proceeds wrapped up somewhere. Right. And maybe there should be essentially an attachment-like motion, and maybe an expedited trial on the view of, I'll let you guys make a full record for the Court of Appeal, because technically TROs as well as preliminary injunctions are appealable as of right in the Court of Appeals. The problem is those appeals take too long to process. Right. So you really have to accelerate, and Rule 65 gives the court the option of saying, we're going to go to trial next week. You put on your witnesses, government. You put on your witnesses, Bolton. I'm going to decide this as a matter of equity. I guess there's the Seventh Amendment right to a jury that's sort of wrapped up in this. But most judges are like, are you kidding me? We're not going to force a jury to listen to this nonsense. You're going to waive a jury if you want the early trial. That's probably what a judge would do, and say you should get the early trial because the Court of Appeals should get the full record. And maybe the Supreme Court would take this. But my prediction would be the Supreme Court will not take this one, because they'll say, we've had enough of this stuff. We're not going to give audience to all of this stuff. We're just not going to do it unless they decide they're going to do it to really make a statement against Trump or against Bolton or against both of them, which is possible. It is certainly possible, because there's going to be a lot more of these books, it seems to me. There are a lot of people in government. So that's my 3 or 4 predictions. What are yours?
I agree with you. I don't think the TRO will work. I don't think any injunctive relief can effectively be given. Although I've been in a lot of cases where judges say, okay, what the hell, I'll give a TRO, preserve the status quo as bad as it is, and we'll take it up later. Right. I've been in those cases. But in this case, too much has happened, in my opinion, for injunctive relief to work.
Right. So
the monetary business.
We'll probably see a ruling in the next week or so, maybe a lot faster. And I bet it'll be very much right down the middle. It'll be right down the middle, spanking both of them.
Very possibly. I think this case is interesting because the whole issue of whistleblowing, which, I don't know whether Bolton qualifies as a whistleblower like Edward Snowden. And yes. The reason is he didn't go to a government agent to reveal what he knew. Right. He went to the public. Right. And is that whistleblowing? I have to read the law again.
The usual law on whistleblowing is you've got to actually go both to a lawyer, and the lawyer's got to go to the government. Right. And it's got to have a certain degree of judicial process wrapped into it. Correct. As opposed to taking advantage of an advance and taking advantage of money and taking advantage of pre-publication publicity, that sort of thing.
But then when is Edward Snowden a whistleblower? He's a classic whistleblower. And
yeah, he's a classic whistleblower, but he routed a lot of that stuff through WikiLeaks. So right. There was an aspect of it where I think it got out of his control, or got out of the control of the typical whistleblowing thing. So, he's kind of a special case. So thanks for your time. We're out of time, but thanks for your time, Rafael. We'll do a part 3. We'll do a part 3 when we see the ruling on this.
Yes, and we have that other topic I want to continue with.
And we'll continue on the topic probably next Friday if you're open to it.
Yeah, sounds good.
That'd be great. Talk to you later. Thanks for your time. Bye. Thanks for the special edition, because this is really helpful.
Okay. Be well.
Tune in next time on The Valley Current.